everyone, and welcome. Today, we are diving into something that affects literally all of us, but is usually buried in completely archaic, dense jargon. We're going to decode how real estate ownership actually works beneath the surface. If you've ever bought a house, rented an apartment, or just looked at an empty plot of land and wondered what rights actually come with it, well, this explainer is exactly what you need. Let's get right into it. Okay, so here is our roadmap for today. We're going to cover 1. The basics of real estate. 2. The different types of land estates. 3. Co-ownership and shared rights. 4. Rights in another person's land. 5. Mortgages and financial encumbrances. And finally, 6. Transferring and protecting your title. I want to kick things off by asking you a pretty fundamental question. Think about it. Do you really own your land? I mean, when you hand over that massive check and finally get the keys to a property, what exactly did you just buy? A lot of us think of ownership like this solid, unbroken block. But legally speaking, ownership isn't a single block at all. It's actually more like a bundle of sticks. It's a bundle of rights. And depending on your specific situation, you might only be holding a few sticks from that entire bundle. Which brings us to Section 1, the basics of real estate, or as I like to call it, dirt versus law. Right, so before we can even talk about those rights, we have to separate the actual physical dirt from the legal concepts attached to it. Legally, land is not just the soil, rocks, and minerals that you walk on. It literally includes the free or unoccupied space for an indefinite distance upwards into the sky, as well as downwards deep into the earth. Basically, when we talk about land and real estate, we are talking about a physical foundation that stretches infinitely up and infinitely down. Kind of wild to think about, right? And because of that, there is a massive difference between physical dirt and legal definitions. We have real property on one side and personal property on the other. Real property is the immovable land and the fixtures permanently attached to it. Think of a house bolted to a concrete foundation. If someone damages this, you can actually recover the property itself in court. Personal property, on the flip side, consists of movable chattels, like your living room furniture. If someone ruins your couch, the law typically only grants you financial damages, not necessarily the return of the actual couch. Moving on to Section 2, let's look at the types of land estates, or your degrees of ownership. Because remember, you don't just own land, you hold an estate in that land. And this is where our progressive layering of legal rights really starts to stack up. The absolute highest layer, the holy grail of real estate ownership, is called the fee simple estate. This represents complete, total ownership of a piece of land and absolutely all the properties on it. When you hold a fee simple estate, your ownership has an infinite duration. You essentially hold the biggest possible bundle of rights recognized by law. Now contrast that absolute infinite ownership with a leasehold estate. With a leasehold, you're just getting ownership of a temporary right to hold the land. A lessee, which is just a fancy legal word for a tenant, gets their temporary slice of the ownership pie from the lessor, or the landlord. You get the right of possession and what the law beautifully calls quiet enjoyment, meaning you can use the place without interference, but the clock is always ticking. It is a layer of ownership that eventually expires. Then there's this fascinating middle ground called life tenancy. This is the ownership of a movable property specifically for the duration of a person's life. It's literally a lifetime-bound layer. The exact moment the life tenant passes away, their ownership extinguishes entirely, and those rights instantly bounce back to the original owner or pass on to a designated next in line. In legal terms, that next person up is called a remainder man. Okay, Section 3, co-ownership and shared rights. Let's talk about sharing the pie. So, what actually happens when these layers of ownership aren't just held by one person, but are held simultaneously by a bunch of people? Well, a super common way to share the pie is through joint tenancy. And what's totally unique here is that all the co-owners have an absolutely equal interest in the property, completely regardless of their individual financial contribution. So if you put in 90% of the cash and your partner puts in 10%, in a joint tenancy, you still legally own it 50-50. If you ever want to change that setup, you have to go through a legal process called severance. That basically breaks the joint tenancy and turns you into tenants in common, which is what actually allows for unequal shares. Now, when you're trying to navigate all these complex shared rights, people usually hire agents, and those agents are bound by a really strict fiduciary duty to act in their client's absolute best interests. Fiduciary duty isn't just some corporate buzzword. It legally binds your agent to 6 vital principles: obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. This whole system ensures that the professionals helping you manage your layers of ownership are legally forced to protect you. Just taking a quick breath here, I do want to give a huge shout out to the excellent resource material inspiring our explainer today, the Real Estate Salesperson Library. Having reliable, rock-solid foundational knowledge like theirs is absolutely essential before we jump into the most complex and tangled layers of ownership, which we are going to do right now. Section 4. Rights in Another's Land. Let's uncover those hidden strings attached. So, what if I told you that random third parties could legally hold invisible layers of rights directly over your fee simple property? Crazy, right? Well, think of an easement as a limited form of ownership on someone else's property. We have positive easements, which entitle someone to actively use another person's property, like, say, a neighbor having the legal right to share your driveway. And then we have negative easements, which entitle a person to prevent a certain use of your property, like maybe stopping you from building a massive fence that blocks their ocean view. The piece of land that benefits from this rule is called the dominant tenement, while the land stuck carrying the burden is called the servient tenement. Another big hidden string is the restrictive covenant. These are basically binding clauses that actually prevent, prohibit, or limit the actions of a landowner. So even if you hold that holy grail fee simple estate, a restrictive covenant might literally dictate that you are not allowed to paint your house pink, or you can't run a commercial business out of your garage. It's a strict limitation baked right into your bundle of rights. All right, Section 5, Mortgages and Financial Encumbrances. Time for the financial reality. We have to talk about the financial side of things because borrowed money directly dictates property rights. Anytime another party has a financial claim on your property, it creates an encumbrance. Simply put, an encumbrance is a limit on how an owner can use real estate brought up by a non-owner. And mortgages are obviously the most common type. They restrict what you can do with the property because the lender has a legal interest in your land. Basically, they hold a hidden string on your property until that debt is completely paid off. Let's actually take a second to clear up a massive point of confusion in real estate terminology: mortgagor versus mortgagee. This sounds totally backward to a lot of people. The mortgagor is actually the borrower. That's you, the homebuyer. You are the one pledging your title as collateral. The mortgagee is the lender or the bank. So wrap your head around this. You, the borrower, actually give the mortgage to the bank in exchange for the loan funds. Okay, our final section, Section 6, Transferring and Protecting Title. How do we pass the baton? So how exactly do we safely pass this dense, heavy baton of rights from one person to another? Well, the exact moment you sign an agreement to buy a property, you don't instantly get the title. There is a gap in time there. To protect yourself during that gap, you lodge what's called a caveat. A caveat acts as this powerful protective shield. It basically puts the whole world on notice that you have a priority interest in buying this property, which stops the seller from sneaking around and selling it to someone else while you're just sitting there waiting to close. And when you're navigating these transactions, two major Latin concepts totally govern the rules of the game. First up, caveat emptor, let the buyer beware. This means the burden is entirely on you to do your own research, inspect the physical dirt, and ask the tough questions. On the flip side, though, for certain highly specialized contracts, the law demands uber rima fide, which basically translates to utmost good faith. That requires the absolute highest standard of full disclosure from both parties. Finally, the actual legal maneuver of transferring property while you are still alive is called conveyance inter vivos. This living, breathing act is the total opposite of intestate succession, which is that super messy, court-driven process of distributing your property if you unfortunately happen to pass away without a valid will. Wow. So we've gone from the physical dirt, stretching endlessly into the sky, all the way through fee simple estates, joint tenancies, easements, and caveats. You should now have a really solid mental model of how real estate ownership isn't just one block, but a fascinating, highly complex bundle of rights. So, with all these layers finally decoded, are you ready to claim your fee simple? Thank you so much for joining me for this explainer, and as always, keep learning.